Hello friends, welcome to the next episode in Domain 1 Security and Risk Management. We are going to discuss investigation and ethics in this video. Last video was some detail which is not 100% exam sensitive for CISSP. It was just to discuss the genesis of the term ethics and how this ethics came into discussion, right, for human beings. Now here, without discussing anything else, let's straight away go back to the key definitions. So when it comes to investigations, investigation is a process of fact finding, and what we do in investigation is try to find out the root cause at some point of time, or we try to find out the liability someone bears as part of some happening, right? So basically there are four types of investigation we discuss in CISSP. They are administrative investigation, criminal, civil, and regulatory investigation. There is a fifth type of investigation which is driven by some compliance requirement or regulatory requirement, which is called third party regulatory investigation, right? One of the example is PCI DSS. Now, what we do in administrative investigation? In administrative investigation, we examine operational issue or security violation. So, if there is a company, that company may have different processes, different security checks, the physical security, technical security, administrative security. So, if there is a violation reported in the company itself, then it calls for the administrative investigation. So operational issue investigations are limited to meet operational conclusions only. Here the documentation need not to be that thorough, and resolving the issue is primary goal. Because, few examples could be like, if you observe a database, an application is accessing a database and the latency has increased for last 1 month. So this is an operational issue, why the latency has increased. Or you are seeing that there have been many access attempt to a critical web server, admin console. So that's a kind of security violation someone is trying to do against the server. So those kind of issue are administrative in nature, and they are dealt with the incident management process a company is running, right? So the incident management process and the underlying the problem management and change management, they all tend to address administrative investigations, right? Now criminal investigation is something where some law has been broken in the society, right? And the people who will investigate, or who will start the criminal investigation are the law enforcement agencies. Basically the police, they can start a criminal investigation. The standard of evidence for a criminal investigation must meet beyond a reasonable doubt. So this sentence you should have in your mind, that the the quality of the evidence for criminal investigation must meet beyond a reasonable doubt standard of evidence. So if the case is presented, all the evidences are presented, so those evidences should meet this criteria. Now civil investigation is an investigation which is done by people on behalf of some legal team for the organization, right? So if there is a dispute between two organizations, which that dispute do not involve any breach of law which is there in the society, so that's a case of civil investigation. And the standard of evidence there is preponderance of the evidence, right? So this sentence should relate to the civil investigation. Whereas regulatory investigations are basically initiated by government agencies. They conduct these investigations, like income tax department can come for a financial investigation, or if you are developing a power plant, or putting some manufacturing unit, then government can do a regulatory investigation to comply to the environmental, ecological standards of the area. So those kind of thing can be initiated by government, but it's not criminal investigation. So regulatory investigation is just that when we run some company, when we participate in some business, so there are some regulatory, environmental, safety, fire, or other requirements which we have to meet, and those can be investigated. If there is a problem reported or someone complained, government may start regulatory investigation. There is a third party regulatory investigation for industry specific standards, like if a company is processing digital payment, they are accepting credit card details, so they may go for the investigation for PCI DSS if required. Now there is this NIST 886, which is a publication which talks about the integration of forensic techniques into incident response. So those organizations who are actually very much prone to provide forensic details and they are at forefront of of law enforcement agencies. They ask a lot of data, so they may have to integrate NIST SP 886 to make their life easy, right? Now when it comes to evidence in the court, any evidence must meet some criteria to be eligible for to be called as an evidence. So the admissible evidence should have these three qualities. The evidence must be relevant to the fact or to the point which actually the lawyers are trying to make. It should not be like some irrelevant point, right? The admissible evidence, the fact that evidence seeks to determine must be material, that is related to the case, right? So being material means it should be related with the case, and relevance means it should be relevant to the point which is being discussed. So this is the distinction here. So these two things, like relevance and being material, it has a very slight difference. The difference is that the evidence must be relevant. It means that it should be relevant to determining a fact or proving a point. So that's the definition of evidence. And material means that it should relate to the case we are discussing. So this is the material. Being material is a broader term, and being relevant is a subset. You can think like that. The evidence must be competent, that is obtained legally. You should not obtain an evidence which is obtained via some illegal way. In that case, what will happen? The case can be can be reversed. Like the people who are actually doing some bad thing, they can say that they have been forced to give this evidence, and they can file another case on the first party. So this is also very important, that the evidence must be competent, that is it has the legal sanction to be called as an evidence, right? What are the type of evidence? We'll quickly go through the different type of evidence. Real or object evidence is any evidence which is in material form, like weapon, clothing, computer, keyboard fingerprints, hard drive. They may also be conclusive depending on the circumstances, like DNA. Though we can't see DNA, but a DNA report can be taken as a real an object or real evidence or object evidence, right? And it must be authenticated, like there should be some chain of custody, there should be some authorization of that evidence by some law enforcement person, like police or like CBI, FBI, whatever, investigating agency actually approves that evidence. Now, what is documentary? Documentary evidence need authentication, and there are two rules in the documentation which we provide to the court. First is the called evidence rule, like the best evidence rule. The best evidence rule says that original copies are accepted only unless certain exception. So all the documents which we provide should be in original. It should not be like a photocopy or fax or some, you know, some drawing of the original. Should not be like that. It should be the first hand reference to the evidence. Like it should be the original copy basically. And what is parole evidence rule? Parole evidence rule says that if there is a dispute between two people and they actually documented the dispute, sorry, they actually documented some sort of agreement between them, and now the dispute is on that agreement, and that agreement was documented. It qualifies for the best evidence rule. Now, if one party says that no, in addition to this documentation, we had an agreement in past that we will deviate from these 3 points or 4 points, so that is not going to be accepted. So no verbal agreement can modify the written agreement. That's the parole evidence rule. Now there is a testimonial evidence. Testimonial evidence is very important. If someone has seen something happening, they can testify it. So the testimonial evidence could be a direct evidence. Someone can go and testify. The testification process is by taking some oath, and that is a legally accepted evidence basically. Now the expert opinion is something which is needed in some cases by some extra experts who can add to some of the points being discussed in the court. Like let's say there was a fire in a factory. Now we need a fire expert who can tell that the complaint, like if the owner of the company is saying that the safety officer didn't do his job properly, then to substantiate this claim, a fire expert can come and give his expert opinion over the presented proof and claims that okay, yeah, so whatever claim is being made is technically or practically feasible or not. So those kind of thing we can ask, experts can come, but those experts should have valid credential. They should be certified, and basically it should not be anyone who claims self-expert. It should be someone who has the proper qualification and degree to prove that he is expert. Now demonstrative evidence is something which supports testimonial evidence, right? So we talked about testimonial evidence. Now it must assist the jury in understanding the case. So someone can come and demonstrate some point, and then with this demonstration the testimonial evidence can be elaborated. So there is a famous movie called some angry young man or something. I'm forgetting. Actually, the movie is about some people who are discussing a case in a room, and there was a murder scene, and one of the person, he actually demonstrated by putting chairs that how much time it will take for murderer to come from one floor to another floor, and that demonstration was acceptable. So those kind of thing can be done in the court. There is another thing called hearsay rule, which is not encouraged in judiciary processes. Hearsay rule is basically someone says that I heard someone saying this or this, but he can't say that who was that source, right? So this is accepted exceptionally, like if in some cases, like if someone is dying and in his last moment he said something, so that kind of thing I think courts accept with some exception. In IT, system logs like sys logs are treated as hearsay and must be accompanied by the testimony of an individual qualified to show eligibility criteria. So if you are presenting some computer log or syslog, there has to be a person, a physical person, who will say that yes, I testify that these are the system logs. These logs are taken on some designated syslog servers, and those servers are, you know, having these credentials, they are being backed up and blah blah blah. So the basically the moral of the story is that the hearsay rule says that any evidence which is not a direct evidence, which is not a testimonial evidence, like a system log, because machine can't talk like humans, so they put this in a hearsay rule. I think you can comment if you have some other best way to explain this, but this is how I understand. Now a system administrator or a log administrator has to come into the code to testify that this is basically from that system, and the time stamp and everything is verified. Now there is something called chain of evidence custody, which is basically all the evidence which is actually collected, it is put somewhere and it is processed. At every stage, the description, time, date, location, named, and relevant circumstances, that has to be documented. If it is not there, if the chain of custody is broken, then there is a problem. Then the evidence will not be treated as a competent evidence, I think. There is another movie I will recommend. It's called Drishyam. Movie. It's a South Indian movie, and there is a Hindi Bollywood adaptation as well. So in the second part of that movie, the movie is in two parts. In second part, you will see that how the chain of evidence, or how the custody is being compromised by the main actor. I'm forgetting the name of the actor, but it's really a nice movie. Okay, now there is another topic. I think I should have discovered, like not discovered, discuss this electronic discovery thing first before discussing the evidence. But anyway, so what is electronic discovery or e-discovery? It's not any tool or something. It's just a name, and basically e-discovery processes or facilitates the processing of electronic information for disclosure. So any company or organization, if they are going they are in a situation where they have to present some information to judiciary, to court, basically they have to follow this electronic discovery reference model, or the model they have, it should comply with the EDRM basically. So what is EDRM? EDRM describes a standard process of conducting e-discovery. E-discovery is what? E-discovery is facilitation or the processing of electronic information for disclosure, right? For taking those information into the court basically. Now it has got some I think nine steps basically. So first is information governance. Information governance ensures that information is well organized for future e-discovery request. So if my system is complying to electronic discovery, e-discovery, it means that all the information which has a potential of being asked by law enforcement, judiciary or something, it is well organized, and it can the data can be taken in some form, exported or printed, or in some form can be taken to the court basically. Now after information governance, let me just zoom it in a little bit. Then comes identification. Identification is basically identification locates the information that may be responsive to a discovery request when litigation is likely. Basically it's just I don't know why these are two steps, but since they are two steps, the first step is that the data is organized for future e-discovery request, like it may have some good format or the presentable way, and location is what data can be asked or can be used for e-discovery process, right? Then preservation ensures information is protected against alteration and or deletion. So here we will be having the integrity check or hashing or check something in place. Collection is gathering the relevant information centrally for e-discovery process. It's a mechanism where we have this some sort of filter that only the relevant information which is required for e-discovery can be gathered here. What is processing? Processing is the rough cut of irrelevant information. Result is screened information. So there is a slight difference between collection and processing here. You can have this distinction in mind that collection is gathering the relevant information and processing is the rough cut. And I have also put the things which are required to be sort of memorized in terms of answering the questions in exam in bold. So processing, you should have this rough cut word in your mind. Collection is gathering centrally, right? Preservation is basically alteration or deletion. Identification is when the litigation is likely to ask, we have to identify the location of information. Information governance is basically future e-discovery requests. So these bold words are the key things which we should have in mind for exams perspective. Now, what is when we process the information, it means we have the rough cut of irrelevant information, and the result is a screened information which we want to process. Now, in review, what we do, we examine the remaining information for relevancy and remove any information protected by attorney-client privilege. Basically, here we will even though we have removed irrelevant information, but even in the relevant information, there may be some sensitive data or some information which is protected by some clause or some sort of understanding between the attorney and the client, or between the general public and the company, like so those kind of things can be reviewed, examined at this stage, right? So review means examine the remaining information for relevancy, that whether it is relevant or not, and removing any information protected by attorney-client privilege. Analysis of information is to perform deeper inspection of the content and context of remaining information, right? So we are not just presenting the result of of whatever we have done. Like let's take an example that there was a database breach, and so till step number 6 we will be removing all the data which is not necessary, not required, or is protected by some sort of privacy law or some sort of understanding between company and the legal team. Now whatever we have, the dry data in hand, that also has to be inspected, reviewed again in context of the case we are fighting for, or in context of the investigation we are doing for, right? There may be some portion of the data which even will not be needed, right? So we will do that type of analysis in step 7. We perform some deeper inspection of the content and context of remaining information. So when we talk of context, it is something which is kind of what we call qualitative, subjective input as well, right? So then what is production? Production is basically formatting for sharing and delivery to the parties such as opposing counsel, right? So it's in legal matters, we don't write like we write general letters or poems or some essays. So legal functioning has got its own way of writing and presenting things, which is very different than the way we speak in our day-to-day life. So that formatting is done at this stage number 8, which is formatting for sharing and delivery to the parties as opposing counsel. Now last stage is to display the information to witness, the court and other parties, right? So this is something, this no need no further explanation. So that's all I think we have covered in this video. Investigation and ethics, we have discussed eDiscovery, and we have discussed the type of evidence. Now we will go further and we'll try to see some type of evidence, you know and there are some other terms, investigation processes, computer crime categories, and the IC square code of conduct. I think I will take that in a different video. Thanks for watching the video, and as always, if you like this video, put a thumbs up. You can subscribe to my channel if you like the content of my channel, and I hopefully will try to finish the syllabus as time permits, because I'm taking this series as a hobby, like to present the content in the way I actually studied to pass this exam. It took 8 months for me to prepare for CISSP, and I appeared for the exam on 30th of December, I think, and I passed in first attempt. And then next month I took CCSP and I passed, and then Azure. So having a good understanding and the way I put the drawings and everything really helped me on that's my own personal experience. So I'm trying to share this information with the broader community, so that if there is some benefit other people can take, I will really be happy with that. Thanks for watching, and let's meet in the next video.